So good morning, everyone. My name is Shazia Khan, and today's session is academic research skills, and we're looking at learning outcome 3 today. So in learning outcome, a summary of what we did in learning outcome 2, and we looked at understanding the techniques that may be employed for academic research, such as we looked at the last session, we looked at qualitative and quantitative research. We looked at positivism, realism. We also look at the different research approaches and why they were so important in regards to comparing one with another, deduction and induction. We looked at combining research approaches. We looked at what research was and why it was so important. We also looked at the writing aims and objectives with reference to examples that you could look at. We looked at the rationale of creative thinking. We also looked at the different types of research that anyone would use to explore and examine stuff. We looked at the SWOT analysis. Excuse me. We looked at observation methods such as structured and unstructured. Excuse me, sorry about this. We looked at hard and soft skills, and also looked at the difference between primary and secondary data. So today we'll be looking at learning outcome 3, and we'll be looking at understanding the importance of ethical considerations in planning and conducting academic research. Excuse me. So the unit aim today is to introduce learners to the research process, the methods and types of research whilst they are conducting a small-scale study. Research skills. So we're going to look at discussing the need for confidentiality in the context to the area of study. 3.2, to identify excuse me, and explain the ethical considerations that may arise from a research program. The indicative content for today's session is these will include informed consent, beneficence, so that means do not harm, respected privacy, which is, excuse me, sorry about this, I've just got a full of cold. GDPR. Why is GDPR so important? When we look at GDPR, why is it so important in regards to, you know, somebody's privacy or respecting someone's, you know, information? Why do you think GDPR is so important? And
so that you get
within your, sorry.
So you'll be able to get the consent.
Okay. But why do you think in your profession it's so important?
It's important because you're supposed to have what it takes to, you know, when it comes to you have to respect people's privacy.
Yeah.
You have to get their consent to be able to do whatever they want.
So the authority, you have to get their authority, don't you? Their permission. You know, you can't just give information out to anyone. So it's really, really important. Safeguarding of the vulnerable confidentiality and anonymity imposes a boundary on the amount of personal data that can be disclosed without consent. Failure to secure and protect confidential information can lead to the loss of business, clients, and to its misuse to commit illegal activity, which is fraud and discrimination. So you need to identify that you are respecting someone's privacy. Otherwise, it's illegal activity. It's a criminal offence, isn't it? You would have elements of fraud there. Your business, if you are disclosing information about a person and you're not protecting their confidential information, you are committing fraud and discrimination. And why do you think that could lead to the business being shut down? Why do you think this issue with confidentiality and protecting someone's personal data is so important?
If you are not careful, it can lead to a criminal offense.
Yeah. Why? And it could get in the hands of the wrong people, couldn't it?
Yes.
And what would they do? They would misuse the information you've given them, such as things like, it could be your national insurance number, it could be your address, it could be your bank details. I've known people that have, been in situations, and especially the elderly as well, that are not some elderly people that suffer from illnesses such as Alzheimer's or dementia and don't remember things, but people just take their details and commit fraud and discrimination, and that in itself is an issue within GDPR. Ethical considerations. So ethical consideration in research are a set of principles that guide your research designs and practices. These principles include voluntary participation, informed consent, anonymity, confidentiality, potential for harm, and results communication. What is GDPR again? We're going to go through that because this is so important. It's been something quite new that's been introduced. Not new meaning like now in the last, but it's been introduced in the last 5 years. Why do you think there was a need to introduce the GDPR policy and rules? Why do you think there was a need? Claude, why do you think we needed to introduce this? Claude, anyone? Adebayo, why do you think we needed to introduce GDPR?
Hello?
Why do you think we needed to introduce GDPR? Anybody answer it? Why do you think?
Because it's important for to respect people's privacy.
Yeah, it's important to protect people, isn't it?
Yeah.
Yeah. And there was a need for it because there was issues of fraud happening. So at the end of 2015, the European Parliament and Council agreed a final draft of the General Data Protection Regulation, which is GDPR, which apply in the UK from 25th of May 2018. The GDPR lays down rules to the protection of fundamental rights and freedoms of natural persons, and in particular the right to the protection of personal data. It aims to improve consumer protection and general levels of privacy for individuals, includes mandatory reporting of data protection breaches, and has an increased emphasis on gaining explicit consent to process information. There were seven principles that were laid down in the GDPR, which we're going to go through: lawfulness, fairness and transparency, purpose limitations, data minimization. Leave it there. Accuracy, storage limitations, integrity, confidentiality, and accountability. It aims to, like we said, protect consumer protection and general levels of privacy. And the whole aim of the GDPR is to protect individuals' personal data. So, Data Protection Bill. The UK also replaces its current Data Protection Act 1998 in the next few months, incorporating the GDPR requirements. The Data Protection Bill has gone through the relevant parliamentary process and is currently in the House of Commons on its second reading. The advice from the Information Commissioner's Office is that many of the GDPR concepts and principles are much as the same as the current Act, and therefore we are complying properly with the current law. Then most of our approach to compliance will remain valid under the GDPR and the new bill, and will give us a starting point to build from. However, there are new elements and significant enhancements, so that we have to do some things for the first time and some things differently. The GDPR new and changed concepts from the Data Protection Act 1998, transparency and consent issues, information to be provided to individuals and permission required from them, children and consent for online services. Why do you think they've introduced this consent for online services? Children and consent for online services. Why do you think that's been introduced?
To respect their privacy.
For people to be able to have
safe.
more knowledge about it.
To make them
one person at a time, please. What was that?
said to respect their privacy and to make them safe.
Why do you think it's an issue with children though at the moment? Do you think it's social media and things like that?
Yeah, social media.
Yeah, social media.
Yeah. They are
Because of
exposed
their
to
age.
social media.
Yeah, it's to protect children, isn't it, from all these issues that are happening on social media. And
Yes.
it's a growing concern though, isn't it, nowadays? You know, to protect it from you know, things like, you know, protect children from predators online. You know, it's really important because there's loads of incidents of, you know, issues where children have been contacted by you know, people online, and the children, their age is quite young, you know, so it was quite a big thing with in regards to consent. The next one is data changes to the definition of personal and sensitive data. So the breach notification, enhanced individual rights, the scope of GDPR. So any or all information relating to an identified or identifiable individual, for example, information held in a manual form or printed out, emails, databases, spreadsheets, photographs on websites, marketing photographs, ID cards and passes, CCTV images, both central CCTV system and any localized system, webcams, web pages, information which may be associated with online identifiers, accompanied by devices, applications, tools and protocols such as internet protocol addresses, cookie identifiers or other identifiers. Definition of personal data. So the definition of personal data is personal information, is simplified in the GDPR. So that is any information relating to an identified or identifiable natural person who they refer to as the data subject. What does this mean in practice? So all staff, students, research subjects, alumni, members of the public where we hold their data is called identified. Also includes, for example, pseudo-anonymous individuals where the university also holds additional information to identify them, and this is called identifiable. Now, in your profession, within the nursing and the healthcare profession, why is it important to look at these issues in regards to personal information? Why is it so important? If you're talking about a patient or a doctor or a nurse, why is personal information so important, and why must it be protected so much? Can you give, for example, if I ask you for some details, can you give me the information straight away? If it's about a patient or something, would you be liable to give me information straight away? What do you think? Could you give me information? If I asked you for information about a patient, would you be able to give me that information straight away? Adi, would you be able to give me that? Tina, anyone?
Yeah, I'm trying to say.
No, because
Yeah.
they have their privacy. You are there to protect them.
Yeah.
So you don't need to give out their information. Because
Could you
those
give
are
it
the
to
people. No, no,
No. Could you give it to a member of their family?
no. You have
No.
to
Good.
ask for his or her conscience
Yeah.
first.
You have to ask for the permission, authority, because it's so important that you don't just give information out.
Yeah.
Legitimate grounds for processing personal data. So it's necessary for the performance of a contract with data subject or to take steps to prepare for a consent for a contract. The university needs to enter into an employment contract with you to pay you in accordance with your contract, to ensure you are subject to its policies, regulations and rules, and to administer your personal pension entitlements. These processes will involve the processing of your personal and special categories data. Necessary for compliance with legal obligation. This would be in relation to UK or EU law only, and action undertaken should be foreseeable to those subject to it. Common law obligations may also be sufficient. If you are relying on a legal obligation to process, we still need to draw this to the attention of the individuals. For example, the university would need to process data to check employees' entitlement to work in the UK or to deduct tax or to comply with health and safety laws. In our privacy notice or data collection notice, we need to make sure that we reference all the processing activities undertaken under legal obligation. Remember, this is the ground for processing should be foreseeable to the individual. Legitimate grounds for processing personal data. So the necessary to protect the vital interests of a data subject or another person where the data subject is incapable of giving consent. This condition is very tightly drafted and can be relied upon when there is no other available grounds for processing the data. For example, medical emergencies. A ground for processing for humanitarian purposes, as an example, would be things like a disaster. Necessary for the performance of a task carried out in public interest or as a consequence of an official authority vested in the institution, the public task. Only where the task is laid out in UK or EU law to which the university is subject, necessary for the purpose of legitimate interest pursued by the university. If you are relying on this, you need to document your assessment of why the processing legitimate. Have you considered the rights and freedoms of data subjects? The public task. We can rely on this lawful basis if we need to process personal data. We look at in the exercise of official authority. This covers public functions and powers that are set in law to perform a specific task in the public interest that is set out in law. We don't need a specific statutory power to process personal data, but our underlying task, function, or power must have a clear basis in law. The processing must be necessary if we could reasonably perform our tasks or exercise our powers in a less intrusive way. This lawful basis does not apply. Universities are likely to be classified as public authorities, so the public task basis is likely to apply to much of our processing, depending on the detail of our constitution and legal powers. For example, we might rely on public task for processing student personal data for teaching and research purposes, but we may need to rely on a mixture of legitimate interest and consent for alumni relations and fundraising purposes. The university needs to consider its basis carefully. We have a document our own decision to help demonstrate compliance if required. We should be able to specify the relevant task, function, or power and identify the statutory common law basis. What is legitimate interest basis for the university? The legitimate interest basis for processing would be most appropriate where the university is using individuals' data in ways they would reasonably expect and would have a minimal privacy impact, or where there is a compelling justification for the processing. For example, in relation to members of staff, the university would rely on the fact that it had a legitimate interest in processing personal data before, during, and after the end of the employment relationship to firstly run recruitment and promotion processes, to maintain accurate and up-to-date employment records, to operate and keep a record of disciplinary and grievance processes, to plan for career development and for succession planning and workforce management purposes, to operate and keep a record of absence and absence management procedures, to obtain occupational health advice to ensure that it complies with duties in relation to individuals with disabilities, to operate and record of other types of leave, including maternity, paternity, adoption, parental, to ensure effective general HR and business administration, to provide references on requests for current or former employees, and to respond to and defend against legal claims. Legitimate grounds for processing data. So consent is so important in regards to any area. This is a legal requirement in regards to, GDPR. Consent is only one of the legitimate grounds for processing personal data under the GDPR. It should only be used where an individual is offered a genuine choice to either accept or decline what is being offered without suffering any detriment. It would not be appropriate to rely on consent, for example, if the individual had no choice but to use the service or to accept the terms, which is access to free Wi-Fi. An example would be if the user consents to receiving marketing materials, would be unacceptable as the two things are unrelated. GDPR has a narrower view of what constitutes consent than current legislation. Consent must be freely given, specified, informed, and unambiguous indication of the individual's wishes. There must be some form of affirmative action, so an opt-out clause. Consent cannot be inferred from silence, pre-tick boxes, or inactivity. Implied consent will no longer be an option. So that comes, like if you're ticking the terms and conditions, or if you're ticking something that you want marketing material, these consent buttons will come then. Consent must be easily revoked as it's given, and therefore clear processes should be in place for the individuals to withdraw consent. Blanket consent for a number of processing activities is now unlikely to be valid. There needs to be consent processes for each separate element of data processing. Legitimate grounds for processing data. Things to do if you are relying on consent to process data. Identifying where you are relying on consent to process personal data. Special categories data. So review how you collect the consent. So information sheets, data collection notices, any forms. Make sure you are collecting a freely given, specified, informed, and unambiguous indication of an individual's wishes. So what are you telling them? Can you offer individuals in the opportunity to consent to certain areas of processing to utilize a positive opt-in? So the tick box. Consider how individuals can revoke their consent. Is it clear from your documentation, your website? And what do you do with consent already collected? So special categories of personal data. Special categories of personal data, also known as sensitive personal data, are broadly unchanged from those listed in the current Data Protection Act under the GDPR, and they are racial or ethical origin, political opinion, religious or philosophical beliefs, trade union membership, data concerning health or sex, life and sexual orientation, genetic data, which is a new one, and biometric data were processed to identify a person, which is a new one. Why is it important to be very careful with sensitive personal data? Why do you think it's so important when we look at sensitive data?
Because it's your personal information and private.
It's personal information. It's personal to the individual. So whatever
Yeah.
they believe in, their religion, you know, it's up to them. Whatever political opinions they have, it's up to them. We shouldn't be able to, you know, it's sensitive. Grounds for processing special categories of data. Explicit consent. So the same strategic consent threshold is required with personal data, freely given specific, informed and unambiguous indication of individuals' wishes. Necessary for obligations under employment, social security or social protection law or collective agreement. This is a wider definition than within the current legislation and is allowed insofar as it is justified by UK or EU law or by collective agreement, providing there are appropriate safeguards for the rights and interests of the individual, necessary to protect the vital interests of data subject or another person where the data subject is incapable of giving consent. This condition is very tightly drafted and can only be relied upon where there is no available grounds for processing the data for medical, for example, medical emergencies. Data made by the data subject, so necessary for the establishment to exercise a defence of legal claims or where courts are enacting their judicial capacity. This is wider definition than within the current legislation. Grounds for processing special categories of data. So it's necessary for reasons of substantial public interest, necessary for the purposes of preventative or occupational medicine for assessing the working capacity of the employee, medical diagnosis, so the provision of health or social care or a treatment or management of health or social care. This provision provides a formal legal justification for regulatory use of healthcare data in the health and pharmaceutical sectors and by providing for the sharing of health data with providers of social care. It's necessary for reasons of public interest in the area of public health. It's necessary for archiving purposes in the public interest or scientific and historical research purposes or statistical purposes. This is a new condition under the GDPR and provides that special categories data can be processed for the purposes of archiving, research and statistics. These procedures would very likely needed to consider if we are relying on using the ground for processing. Criminal convictions, and this is really important when it comes to issues of fraud and things like that. Criminal convictions and offences. So data in relation to criminal convictions and offences are not categorised as sensitive under the GDPR, which they are under the Data Protection Act. However, they have not lost their sensitivity, and the GDPR states that this type of data can only be processed under the control of an official authority or where the processing is authorised by the UK or EU law, which provides appropriate safeguards. There will be a specific section within the Data Protection Bill related to law enforcement which would deal with the processing of the prevention, detection, investigation or prosecution of criminal offences or the execution of criminal penalties. Is that a good thing to have when it comes to data protection? The issue of criminal offences. Is it good that we've got that in the GDPR? Because are criminal offences committed when it comes to GDPR?
It's not a good thing, I think.
Sorry, what's that?
You're asking if it's
Hello?
a good thing, yeah?
Yeah. What do you think a lot people commit criminal offences when they use GDPR? What in GDPR? What is a criminal offence? When it comes to data, what could be a criminal offence?
By not using right information
Yes. That by not using the right information, by using other people's personal data. So data protection principles, there's 7 principles, okay? First one is data processed lawfully, fairly, and in transparent manner, which I mentioned earlier, which is lawfulness, fairness, and transparency. The inclusion of principle of transparency and new provision within the GDPR. Number 2 is data obtained for specific, explicit, and legitimate purposes, and not further processed in a manner that is incompatible with those purposes. So the current Data Protection Act 1998 has similar restrictions on the processing of data. The GDPR provisions include processing for public interest or scientific purposes, widening the scope of further processing, archiving, scientific, historical research, or statistical purposes would not be seen as incompatible with this purpose. However, there would be a need to consider pseudo-anonymity in the data. Number 3, data process is adequate, relevant, and limited to what is necessary. So the current Data Protection Act uses the term excessive. The GDPR requirements take the opposite view and only permits processing of data that is necessary. Number 4, data is accurate and where necessary kept up to date. There are new rights for individuals in the GDPR, data erasure, data correction, etc., which impact on this principle. Number 5, data should not be kept longer than is necessary for the purpose. The GDPR expands the list of exceptions permitting the storage of data for longer periods where the data is being processed for archiving purposes in the public interest and for scientific purposes. And number 6, appropriate technical organizational measures against unauthorized or unlawful processing, loss, damage, or destruction. Accountability. The university is responsible for demonstrating that we comply with the 6 principles. Data processed unlawfully, fairly, and in transparent manner. So lawfulness is what are the grounds for processing personal data and special categories data. There are no grounds for it. It may be useful. Remember, consent is the only one of the grounds you can rely on. That may be others that are relevant. Fairness, if you are relying on the consent, it may be given specified, informed, and unambiguous indication of individuals' wishes. Ensure there's a form of clear affirmative action, so a positive opt-in. What information are given individuals in order for them to make the choice? Transparency. The university's privacy notice will be updated. However, consider whether you need your own privacy notice for specific processing activities. Make sure their notices you use are comprehensive and clear. And also they're written in plain language so they're easily accessible. Data obtained for specified, explicit, and legitimate purposes and not further processed in a manner that is incompatible with those purposes. Purpose limitation. Decide what your basis is for collecting the personal information, special categories information, and make these known to the individuals concerned. For example, in terms and conditions on the website, in any literature. Make sure you consider whether you need to draft your own privacy policy for the processing or whether you link to the university policy. Have a clear data collection statement which is explicit with regard to the use of data. This is essential in order to ensure specified, informed, and unambiguous consent. Make sure you include the retention period for the data. The GDPR also sets out rules. Oops, let's go back. GDPR sets out rules on factors to be taken into account to assess whether new processing purpose fits with the purposes originally communicated to the individual. So they'll look at things like, is there any link between the original and proposed new purpose, the context in which the data was collected, the nature of the data, whether it is special category or criminal offence data, the possible consequences of the new processing, the existence of safeguards such as pseudonymous or encryption, processing for archival purposes in the public interest for scientific, historical research, or statistical purposes. Data is adequate, relevant, and limited to what is necessary. Data minimization. Only collect and use the data when you actually need to in order to carry out purpose. And importantly, only what is compatible with the reasons and the purposes which the individuals were informed of, or the purposes for which you are legally entitled to hold the information. Always refer back to the privacy notice, data collection notice. Importantly, don't collect any data in case it might come in handy. Data is accurate and where necessary kept up to date. Accuracy. So make sure that any personal data or special categories data collected is recorded accurately. Why do you think accuracy is so important?
It should be,
Why do you think?
I believe it's important to make it well organized, well structured.
Yes, structured, well organized, accurate, so that if there's any changes that the individual notifies us of any changes, and ensure that the data is not inaccurate, and it should be amended, with all the changes. Data should not be kept longer than is necessary. Storage limitations. We cannot hold data which permits identification of individuals any longer than is necessary for the purposes notified to the individual in our privacy notice. Data collection notice can be held for longer as long as this is for the purposes of archiving or for scientific or historical research or statistical purposes. Remember that when you have archived the data, or if you are using it for scientific historical research or for scientific statistical purposes, it still comes under the principle requiring appropriate technical and organizational measures to be put in place. Consider pseudonymization at this stage. Only the purpose for holding the data is no longer valid or the assigned retention date has passed. You should not continue to hold the data. We have a legal responsibility to make sure that information is held securely and that it is securely disposed of at the end of the retention period. Appropriate technical and organizational measures against unauthorized or unlawful processing, loss, damage, or destruction. Integrity and confidentiality. This principle applies to both personal and special categories data, which must be kept secure. The data must be processed in a manner that ensures appropriate security, including protection against unlawful processing, accidental loss, destruction, or damage. The information must only be available to those with the right to see it. So anyone that has, permission to see this data needs to look at it. Matters to consider: transferring information from one section, function, department to another, or transferring externally. It's often essential to do this, but consider what information actually needs to be transferred to whom and how it is possible to ensure the confidentiality and security of the information. Remember, even if you're transferring data, it is still our responsibility to ensure its safety. Information is disclosed to members or staff in order for them to carry out specific roles. This information should not in any under circumstances be disclosed or handed over to anyone other than those who need to see it. Staff must be careful with memory sticks, laptops, and other portable media. They must use encryption passwords and consult the university's security policy. Information security, paper records. Appropriate storage for paper records, manual records would include locked metal cabinets with keys to limited authorized staff only, locked drawer in a desk with keys to limited authorized staff only, locked room access to be by key or coded lock, where access to the key code is limited to authorized staff only. Does your school department have a clear desk policy? If not, there are risks of having paperwork on your desk. What is the risk of having all the paperwork around your desk overnight or on weekends?
It can expose the person's data, like
Yeah. So
information.
is it best to put everything away locked up?
Yes.
Yes. So appropriate disposable for paper, so secure disposable via an accredited confidential waste disposal and shredding. So this is so important. If information you want to get rid of, needs to be shredded. Accountability, when we look at GDPR, the university is responsible for and should be able to demonstrate compliance with the 6 principles. So what does this mean in practice? You must adhere to approved policies and codes. How can we measure this? You must have a robust paper trails of decisions related to data processing. Good records management is essential. Number 3, staff training. Ensure all staff know about data protection legislation. Encourage attendance. Number 4, where appropriate, use privacy impact assessment. Excuse me. Excuse me. Where appropriate, use privacy impact assessments, which are an assessment carried out to identify and minimize non-compliance risk, especially on high-risk processing. Excuse me. Number 5, audits of compliance through internal and external auditors. Number 6, use of data protection by design measures. And number 7, regular reports to the compliance tax group. GDPR and individual rights. So the right to be informed, privacy notice, data collection, the right to access, that's a subject access request, the right to rectification. If the data is inaccurate or incomplete, we must respond to a request for rectification of data within a month. The right to erasure, previously known as the right to be forgotten. This does not provide an absolute right to be forgotten. Individuals have a right to have personal data erased and to prevent processing in specific circumstances, such as where the personal data is no longer necessary for the purposes which it was originally collected, where the individual withdraws consent or objects to the processing and there's overriding legitimate interest, and where the data is being processed on the basis of the university's legitimate interest. If the information has been shared with other universities, responsibility to inform them of the individual's request for data erasure. The right to erasure does not apply for the exercise of the right to freedom of expression and information, for compliance with a UK or EU legal obligation, for the performance of public interest task or exercise of official authority, for public health reasons, for archival research or statistical purposes, if required to establish, exercise or defend legal claim. The right to be informed. The GDPR requires us to be transparent, as we mentioned earlier, and to provide accessible information to individuals about how we use their information. The usual way in which to provide this information is through the use of a privacy notice. The term privacy notice is used to describe all different ways in which organizations can provide privacy information to individuals on the web. In any literature, the privacy notice needs to be comprehensive. The starting point of a privacy notice should be, who is Bangor University? This is an example, and if it is specific notice, then it should also include who is the school, department, what is the university going to do with individuals' information, the purpose for collecting the information, who will it be shared with, the important details, to include everything, details of any transferred outside the EU, the retention period of the data, the individual's right to access the data and to rectify, erase and restrict it, the complaints process, whether there is statutory or contractual requirement to provide the data, if there's an automated decision making, what's the source of the data. The privacy notice must be provided at the point in which the individual hands over the data. We can't assume because someone engages with one service that they will be happy for their data to be transferred to another. If the data isn't obtained directly from the individual, the university should provide their privacy notice to the individual within a month of receiving the data. The right of access. Individuals have the right to be told whether the university is processing their data and to receive a copy of that data. The individuals also have the right to be provided with supplemental information about the purpose of processing their data. In order to make a request to see or obtain a copy of the information, an individual should make a request in writing within the university. The request should be made to info compliance at Bangor or by post to Lynette Hunter in corporate services. There is no charge for making the request, and the request must be dealt with without delay and at the latest a 1 month receipt of the request. Matters to consider. So can we make data more accessible to individuals so that they can see the information themselves without needing to use the right of access procedure? Are we making students aware that they can see and amend data within My Bangor? Can we deal with requests for portability of data, so which data can be easily exported in structured machine-readable formats? Children's personal data in digital environment. The GDPR contains new provisions intended to enhance the protection of children's personal data in digital environment. In the GDPR, children are identifiable as those who require specific protection under the regulations. Will the rules in relation to children affect you? Proposals in relation to online services would mean children aged 13 years old or above would be able to consent to their data being processed. For children under 13 years old, their parents or guardians would need to consent. Withdrawing consent will also be simplified for children. Privacy notices for children. Where services are offered directly to a child, organisations must ensure that the relevant privacy notice is written in a clear, plain way that a child will understand. Children's personal data for other information, other circumstances. For all other data protection issues, children can make their own decisions if they have capacity or GILIC competencies. Now, GILIC competencies, whether or not a child is capable of giving the necessary consent, will depend on the child's maturity and understanding and the nature of consent required. The child must be capable of making a reasonable assessment of the advantages so that the consent, if given, can be properly and fairly described as true consent. What age do you think a child should be giving consent? Anyone, do you think there's a specific age that a child should be giving consent, or what you feel that a child should be?
18.
Yeah, do you think 18 should be the cutoff point, not 13? Do you think at 13 a child is still young as well?
Is too early. The child
I
will not be able to know the risk.
Yeah, I think 13 is too young for social media. I think it should stick to maybe 16, 18.
18.
But it's quite young, isn't it? So the child sometimes doesn't know what, certain things are, like you said. Transfer of data outside the European Union. So transfers of personal data outside the EU continue to be regulated and restricted in certain circumstances. The university can transfer data outside the European Union where the receiving organisation has provided adequate safeguards. Individuals' rights must be enforceable and effective legal remedies for individuals must be available following the transfer. Examples of adequate safeguards would be a legally binding agreement between public authorities or bodies, binding corporate rules or agreements governing transfers made between organisations within a corporate group, standard data protection clauses in the form of template transfer clauses adopted by the Commission, standard data protection clauses in the form of template transfer clauses adopted by a supervisory authority and approved by the Commission, compliance with an approved code of conduct approved by supervisory authority, certification and an approved certification mechanism as provided for in the GDPR, contractual clauses agreed, authorised by the competent supervisory authority, or provisions inserted into administrative arrangements between public authorities or bodies authorised by the competent supervisory authority. Transfer outside the European Union. Again, any current data protection clauses which are put into the contracts will need to be updated to ensure they remain compliant with GDPR requirements and the new data protection legislation. To do now, review and map key international data flows, to consider what data transfer mechanisms you have in place or whether these will continue to be appropriate, and to review contract clauses to ensure the requirements remains compliant. Personal or special categories data breach. The GDPR will introduce a duty of to all organisations to report certain types of data breach to the Information Commissioner's Office, which is ICO, and in most cases are also to the individuals affected. A personal data breach means a breach of security leading to the destruction, loss, alteration, unauthorised disclosure or access to personal data, special categories data. The university will have to notify the ICO where the breach is likely to result in a risk to the rights and freedoms of individuals and must do so within 72 hours. Failing to notify a breach, which when required to do so, can result in a fine. In addition, there will be a significant fine for the breach itself, up to 10 million euros or 2% of an organisation's global turnover. The university will be expected to keep an internal breach register noting all personal special categories data breaches. We should notify the ICO of a breach where it is likely to result in a risk of rights and freedoms of individuals. The individuals themselves will also need to be notified in most cases. Whether to notify or not has to be assessed by the university on a case-by-case basis, and all staff will be made aware of the university's internal breach reporting procedures. Issues to consider when assessing. Would the breach have a significant detrimental effect on the individuals affected, for example, result in discrimination, damage to the reputation, financial loss, loss of confidentiality, identity theft, or any other significant disadvantage? The ICO guidance states that they would expect the following information to be shared: the nature of personal data breach, including, where possible, the categories and approximate number of individuals concerned, and the categories and appropriate number of personal data records concerned, the name and contact details of the data protection officer or other contact point where information can be obtained, a description of the likely consequence of the personal data breach, a description of measures taken or proposed to be taken to deal with personal data breach. Staff responsibility. Staff responsibilities. So staff, including voluntaries working at the university, external members of the committee and contractors, have responsibility to ensure that personal and special categories data is kept on a need-to-know basis, treated sensitively and disposed of securely. It is disclosed orally or in writing, intentionally or accidentally, to any unauthorised member of staff or third party. If you need to share personal or special categories data with a member of staff with an external third party, make sure you have satisfied yourself that you have the right to know the information, and if they have that right, make them aware of the need of confidentiality. So don't hesitate to ask questions. Why do you need it? What powers do you have to request it? Compliance with data protection legislation is both personal and an organisational responsibility. Ethical consideration. Ethical consideration can be specified as one of the most important parts of the research. Dissertations may even be doomed to failure if this part is missing. According to Bryan and Bell, the following 10 points represent the most important principles related to ethical considerations in dissertations. Research participants should not be subjected to any harm whatsoever. Respect for the dignity of the research participants should be prioritised. Full consent should be obtained from the participants prior to the study. The protection of privacy of research participants has to be ensured, Adequate level of confidentiality of the research data should be ensured. Anonymity of individuals and organisations participating in the research has to be ensured. Any deception or exaggeration about the aims and objectives of the research must be avoided. Affiliations in any form, sources of funding, as well as possible conflicts of interest have to be declared. Any type of communication in relation to the research should be done with honesty and transparency. Any type of misleading information, as well as representation of primary data, finding it is a biased way, must be avoided. In order to address ethical considerations of your dissertation in an effective manner, you need to expand the discussions of each of the following points, at least one in one paragraph. Voluntary participation of respondents in the research is most important. Moreover, participants have the right to withdraw from study at any stage if they wish to do so. Respondents should participate on the basis of informed consent. So the principle of informed consent involves researchers providing sufficient information and assurance about taking part to allow individuals to understand the implications of participation and to reach a fully informed consideration and freely given decision about whether or not to do so without the exercise of any pressure or coercion. Number 3, the use of offensive, discriminatory or other unacceptable language needs to be avoided. Number 4, privacy and anonymity of respondents is of paramount importance. Number 5, acknowledgement of works of other authors used as part of the dissertation with the use of Harvard, Vancouver referencing system. Number 6, maintenance of highest level of objectivity in discussion and analysis throughout the research. And number 7, adherence to the Data Protection Act 1998 if studying in the UK. In studies that do not involve primary data collection, on the other hand, ethical issues are going to be limited to the points D and E above. Most universities have their own code of ethical practice. It is critically important for you to go thoroughly adhere to this code in every aspect of your research and declare your adherence in ethical considerations as part of your dissertation. So these are some of the references that we've used in today's session. If you've got any question, please ask. Is there anyone got any questions? And we've finished learning outcome 3 now. Has anyone got any questions?
Yeah, so this learning outcome, these references or link, you can get everything.
You can go to these to get more resources. You can go to your Moodle page to get extra resources to help you when it comes to doing the assignment area.
Okay.
And a lot of the resources are available on these slides as well, which are quite detailed. So, you could use them to help you do your assignment as well. Has anyone else got any other questions? Anyone? No? Okay, then. So thank you for attending today's session, and thank you for your patience. And there was quite a lot to go through on GDPR, so there's a lot of background reading, additional reading for you to do. And also, the last session is tomorrow, which will be the assignment discussion. Okay, so I will see you lot tomorrow at 9 o'clock if you haven't got any more questions or anything. Is that okay?
Yeah, that's fine. Okay.
Okay. Okay, I will see you tomorrow at 9, okay? See you later. Bye.
Bye.
Bye. Thank you.
Bye. Thank you. Bye.